Hi, I'm Nicola, Head of Employment at Clapham Collinge. Today I'm going to be dividing my discussion into two halves. So the first half is going to be dealing with charities as employers, because as Neil says, unfortunately, just because you're a charity, you're not exempt from employment law. So it's important that you know what your obligations to staff are. Secondly, I'm going to be exploring with you the employment status of staff, so discussing with you the various categories of individuals in the workplace and how you can differentiate between those. So whether you're an incorporated charity or a trustee, it's essential that you're aware of your obligations to your employees. I've set out here 5 of the main acts that we get our employment law from. They're not the only acts, there are many that we refer to, but these are the most important ones. Employment Rights Act, you may have heard of. This is the main framework that governs modern day employment law, and it's primarily concerned with all rights for individual employees, so rights to notice, rights not to be unfairly dismissed, for example, time off work, redundancy. National minimum wage, I think, is rather self-explanatory. You may be aware that it goes up on the 1st of April each year, and it's different for different ages of workers. Working time regulations, so these govern the daily rest breaks that employees and workers are entitled to, for example, average weekly working hours, and holidays, which is obviously most important for employees. The Pensions Act brought about changes recently that you may be familiar with, so that employers now have to auto-enrol employees onto a pension scheme, and that again applies to all employers. And lastly, but certainly not least, is the Equality Act. So it's something you may be familiar with. This deals with discrimination. Individuals are protected if they have one or more of 9 protected characteristics. So for things such as age, gender, sex, pregnancy, they shouldn't be discriminated against or subjected to any unfair treatment. ACAS is a really good resource. I don't know if any of you are familiar with this. It provides some good support for employers, and it's there to resolve any workplace disputes that you might have with employees. It also provides a conciliation service. If you go online, it's got some really helpful guides in relation to the disciplinary and grievance issues, so please do take a look. I must say they can't give you legal advice, but they certainly can point you in the right direction. And finally, many of you will have in place staff handbooks. I think the larger you are, the more likely you're going to have these. They contain policies and procedures in the workplace in relation to matters such as disciplinary and grievance issues. So just to recap, it's important that you're aware of your legal obligations as an employer, and you keep up to date with any changes in legislation that I addressed on the previous slide. So I've set out here some very brief top tips ensuring your obligations as an employer are fulfilled. Review your documents. I can't stress this enough. It's very important, especially contracts of employment, policies and procedures, that they accurately reflect any changes in legislation. It's also fairly commonplace for employers to get templates online, which is there's nothing wrong with doing, but you need to ensure that they are bespoke and they fit for purpose with your charity. Consider having an HR subcommittee in the board. This is, again, maybe for larger charities, dealing with staffing issues can be quite time consuming. It's important that you get it right, so it might be advisable that you delegate any staffing issues to one or more of your trustees. Workplace investigations. So these often come about if, for example, an employee raises a grievance, or if you have some allegations to put to them in relation to disciplinary issues. You are required in the law to undertake a thorough investigation. That investigation needs to be done promptly. So if you're very busy with other things, which I'm sure you all are, you might want to consider outsourcing it to a third party. Whilst that might be costly in the short term, it could save you a fortune in the future. Settlement, I mean, this could be a rather contentious thing. I'm sure we all have disgruntled members of staff, and the last thing you want to do is pay them any money. But often, if they're threatening to issue legal proceedings against you, it could be more commercially viable to do that. But always consult lawyers, I would say, on that issue particularly. Maximise employee output, so just make the best use of staff by regularly reviewing the staffing levels to confirm that you're getting the best from them and that they're being used to effectively meet the charity's business objectives and charitable aims. Pension schemes, we talked about those earlier very briefly. Just be aware what your obligations are. In April, the employer minimum contributions are going up to 3%. That's something just to be mindful of. And finally, last but not least, volunteers. Be aware of the status and obligations owed to volunteers. I will discuss this in more detail at the second half of the presentation. So I've added dignity in the workplace because there's been a few surveys recently which have demonstrated that there's been some unfair treatment within the charity sector. Some of you may know that in January this year, the Independent Commission found that Oxfam failed to keep their working environment in check, tolerating sexual misconduct and bullying. Save the Children, 25% of the 700 staff surveyed said that they've been subjected to discrimination and harassment. And RSPCA Unite, the trade union, carried out a survey, and a third of staff members within the last 12 months claimed that they had been subjected to bullying within the workplace. So what can you do to prevent this? It's all about the policies. I discussed with you earlier staff handbook and why it's important to have a handbook in place, particularly in relation to issues with bullying and dignity at work. I would always suggest you have a bullying and harassment policy and a grievance policy in place, just so the employees are aware of what they can do should they experience such issues. The Charity Commission has recently made revisions to its 2017 safeguarding strategy, and it now gives specific guidance on protecting volunteers and staff, and it also states that all charities should have clear policies and procedures in place on bullying and harassment. And the National Council for Voluntary Organisations, they've published a new code of ethics which also encourages charities to review all of their policies, particularly concerning dignity at work. So if we move now on to employment status. Broadly, there are three categories of protected individuals in the workplace. These are employees, workers, and self-employed. But why is it important to define the status of these individuals? Well, the main reason is the core legal protections. Certain employment rights are only applicable to employees, including, for example, the right not to be unfairly dismissed and the right to receive statutory redundancy. ACAS, which I discussed with you earlier, that only applies to employees. Failure to adhere to the ACAS code in relation to tribunal proceedings, for example, can result in sanctions being applied to you as an employer. TUPE, I'm not going to go into any detail on this subject because I could speak for hours on it, but employees would be transferred to any buyer of the charity should TUPE be applicable. Vicarious liability, again, an employer is vicariously liable for any acts done by its employees in the course of their employment. Again, so it's very important to be aware of who is employed in your organisation. Liability insurance, you're required to take it out to cover the risk of an employee injuring themselves whilst at work, and it may not always extend to third parties, something to be mindful of. And again, health and safety. There's statutory duties owed to employees relating to health and safety. So just to clarify, volunteers, if they're genuine volunteers, have no employment rights whatsoever. Same with self-employed contractors. The position changes if somebody's found to be a worker. A worker has limited employment rights, so they have rights to things such as the minimum wage and paid annual leave. An employee who works under a contract of employment, which I'll discuss with you in a minute, is entitled to the full range of employment rights, including, like I've discussed earlier, the unfair dismissal or statutory redundancy payment. So how do we determine the status of an individual? The Employment Rights Act says that an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment. And then it goes on to say that a contract of employment means a contract of service or apprenticeship whether express or implied, and if it is express, whether oral or in writing. So it's not necessarily so easy to determine. This definition has been extensively explored and construed through case law over a number of years. You can't simply look at this to determine whether or not an individual is employed, so you need to look at the key factors which have been identified in case law. So the key case that us employment lawyers rely on in determining employment status is ready-mix concrete, and they've set out 3 factors that constitute what we call the irreducible minimum that need to be in place to allow a contract of employment to exist. Personal service. If an individual is able to send a substitute, for example, in their place, it points to there not being an employment relationship. If it is them that has to perform the services personally, they're more likely to be an employee. Mutuality of obligation, this is a key one. If there's an obligation on you as the employer to provide them with work, and them as the individual to accept that work, then again that points to the likelihood of there being an employment relationship. Control. Control can cover a number of things: the way the work's carried out, how it's carried out, where it's carried out, when it's carried out. The degree of control is important, and the courts will look to see how much control is exercised over the individual to determine whether or not they're likely to be an employee. So, to clarify, if all of these 3 things are present, it's likely that the individual is an employee. If only 1 or 2 are present, a worker. If none are present, they're more likely to be self-employed. So a number of you here likely have volunteers providing services for you. It's important to note that just because you give them the label that they're a volunteer, they're not necessarily a volunteer. They could be a worker or they could be an employee. So it's important to look at what the reality of the situation is. In a genuine volunteer arrangement, there should be no mutuality of obligation. So there should be no obligation on you to provide work to the volunteer and no obligation on them to accept it. Sadly, there's no legal status, legal definition of volunteers, and so it's not so easy to decide whether or not someone is likely to be a volunteer. And this ambiguity has generated a wealth of case law. So I'm just going to briefly touch on 2 cases where volunteers in the charity sector were actually found to be employees. A lady called Mrs. Chowdhury, she was an administrator for the Migrant Advisory Service. She worked for 4 days a week and was paid expenses. However, when the tribunal looked at it, they found she actually incurred no expenses. She was also paid when on holiday or sick. In all the circumstances, the tribunal found that she was likely to be an employee, and that was the ultimate finding when it went to the Employment Appeal Tribunal. The second case is a gentleman named Mr. Murray. He worked for Newnham Citizens Advice Bureau. He had an agreement with the employer. He was told he had to volunteer at specific times. He had to carry out minimum work, and there was an enormous degree of control exercised over him. In the circumstances, the tribunal found that he was actually an employee and not a volunteer. In both cases, these individuals therefore had rights to bring claims for unfair dismissal against their employers. So how do you avoid making volunteers workers or employees? Payments is crucial. Only make payments if they've genuinely incurred expenses. If you pay them for anything else, it could be construed as wages and it runs the risk of them being found to be an employee. Perks. Avoid extending any benefits that are offered to employers to employees as well, to volunteers as well. This could be seen as a substitute for payment, i.e. for wages, and again it could point to an employment relationship. Obligations, I've discussed mutuality of obligation quite a bit throughout the presentation. Again, don't put any pressure on them to accept work, and please don't apply sanctions to them if they refuse to do any work for you. If you do use any kind of agreement with them, adopt flexible language, so use terms such as "we would like you to," "our preference," not terms such as "you must do this." And ultimately, regardless of what their status, always treat volunteers fairly. So something we do at Clapham Collinge is we can draft you up volunteer agreements. These are very simple documents, but they enable you to control the relationship and set out the expectations that you have of your volunteers without inadvertently creating an employment status. So they usually include things such as the volunteer's role, induction and training, supervision, support and flexibility, expenses, insurance, and health and safety. We do also have a clause in the end of our agreements that expressly says that no employment relationship is intended and that it's not intended to be a legally binding agreement, and that is very important in these documents. So in summary, always understand what your obligations are as an employer, even if you have a majority of volunteers, just in case they are actually deemed to be employees or workers. Take note of the dignity at work issues we discussed, especially with bullying and harassment, and ensure that you protect all individuals against that, and look after your volunteers. That's it for me.